Welcome to the channel States and Migration in Europe. Today, we are discussing the UK migration and the ECHR, the European Court of Human Rights. So recently, the government of Boris Johnson collapsed for a variety of reasons. One important was the Northern Ireland Protocol. But there were also other reasons, and an important one that has taken up my attention is the failure of the eviction of immigrants in the UK to Rwanda as a result of the intervention of the European Court of Human Rights. So it was an important policy for the Johnson's government because the control of immigration has become in the UK for a number of years a very salient political question. And the intervention of the ECHR has had the result to weaken possibly decisively the Johnson government in the previous weeks. So the failure of the Johnson government to implement its agenda to control immigration and to reduce immigration was certainly a key factor in its ultimate collapse in recent years. In recent weeks. So to discuss this issue and the clash between the British government and the ECHR, I am very glad to have with me Alain Zysset, who is a top expert on the ECHR. And we will discuss with Alain the rising conflict between the British government and the ECHR. So everything looks like the migration policies of the Johnson government have been increasingly clashing with principles defended by the ECHR, which are not in themselves principles related to migration policies. It's because the migration policies of the British government were affecting deeper principles of the political system that there has been this rising conflict. And this conflict is bigger than the Johnson government per se. The question of the control of immigration has been lasting in the British debate for a while, and even now the race for the leadership of the Conservative Party has been seriously also characterized by the question of whether the UK should exit the European Convention on Human Rights. So Alain, welcome. Thank you for being here. So please share your thought with us on this contradiction and this conflict between the British government, its policies in the field of migration, and the ECHR.
Sure. So thank you very much, Emmanuel, for inviting me. So I think that I would partly agree with you on what you just said. So on the one hand, I think there's now a clear conflict between, let's say, the UK government and the European Convention on Human Rights and the European Court of Human Rights. There's a tension and maybe a conflict that has been running for a number of years, actually. So the migration crisis, if we want to call it that way, builds upon, I would say, more than a decade of increasing tension. So it may be important to say a couple of things about this underlying tension. So that's the first thing. And the second thing is that I'm not sure, actually, that the Johnson government collapsed because of this issue. The reason is simply that, and that's also, let's say, a broader pattern in UK politics, especially in the Conservative Party, which is that they want to basically rearrange their relationship with the European Convention, and that is in the manifesto of the party. And one of the remaining contenders for the leadership of the Conservative Party, Liz Truss, said or wrote that it might be necessary to leave the European Convention system. So we are here sort of building upon a very, very strained relationship between the UK government and the obligations that derive from being a party to the European Convention. And so there's a strained relationship. And of course, the migration crisis further builds upon that. Okay. So if you want, I can say a little bit more about why there is such a strained relationship.
Yes, I think the big question is what has been the source of a clash? What kind of principles have been at the root of this conflict between the British government and the ECHR?
Yeah, so I think we can distinguish at least two levels in that strained relationship. The first is that, and this is becoming a bit legalistic, but I will try to really just say the essential things. So the UK doesn't have a written constitution, and it has this long-standing tradition of being quite reluctant towards entrenching fundamental rights. So that is not to say that rights do not exist in UK law, they do, but there is a tradition against entrenching rights into a single list that would typically take the shape of a constitution in many other countries. However, the UK has signed and ratified the European Convention on Human Rights. Actually, the UK was one of the most active promoters of the European Convention in the early 50s. We can talk about that on the side if you want. But more importantly, the absence of a constitution and the absence of rights being entrenched in the law explains the status that the European Convention has taken, which is basically an act of parliament, which is called the Human Rights Act, that was enacted in 1998. And so it's important to look at this act if we want to understand the broader legal relationship between the UK and the European Convention, and therefore to explain the strained nature of that relationship. And if you look closely at the Human Rights Act, you will see that, most importantly, UK courts cannot strike down legislation that is incompatible with the European Convention. The only thing that courts can do is to make what we call a declaration of incompatibility. So basically that is re-empowering Parliament, because it's basically just signaling, indicating to the other branch of government that there is an issue that they need to address. But you can wonder if Parliament indeed does that. In most cases, it has, but in some cases, it hasn't. So if you want, I can give you an example where the Parliament has been very, very slow at addressing an issue. And I think it's important to cite this example because I think it's basically the beginning of this strained relationship in recent years, in the last 2 decades or so. So it's a case called Hurst against the UK at the European Court of Human Rights. And it's a case that involved basically, on the one hand, the right to free and fair elections, and on the other, a piece of domestic legislation that introduced a blanket ban for prisoners, for convicted prisoners, to exercise their right to vote. And the European Court of Human Rights ruled that this blanket ban is in violation of the European Convention. And you can imagine how the UK political class, in particular the UK, the Conservative Party, reacted to that, because it basically said that this is interfering, it is intruding into our domestic democratic decision to shape policy and law around prisoners' rights, essentially. But having researched this particular case, I can tell you that the European Court of Human Rights did not question the democratic legitimacy of that piece of legislation. Actually, most of the judgment relies on the fact that this judgment focused on the blanket aspect of this legislation. So, for instance, it questioned the proportionality of that piece of domestic legislation. In other words, the problem was that it didn't matter whether you had committed a petty crime or whether you were, let's say, a serial killer. That difference in the offense that you committed did not make any difference to you being able to exercise, and in this case, not exercise at all, your voting rights. This is the extent to which perhaps the legal technicalities matter. But if you want to explain where things started to shift and to worsen in terms of the relationship between the UK government and the European Court of Human Rights, the Hearst case is a useful starting point. And then with the rise of the Conservative Party in power, they have continuously criticized and attacked the European Court of Human Rights. And the specific case of the migration policy of the Home Office basically sort of builds upon that increasing tension. So it's important to keep in mind that there's actually a quite long history, and a history that is both informed by specific cases like the Hearst case, but also by sort of underlying legal and structural parameters, especially the fact that the Human Rights Act is both enabling individuals to claim their rights, but it is to some extent also reaffirming what we call the supremacy of Parliament.
Mm-hmm. And in the recent case about migration, do you have any idea of what was exact? So in the Hearst case that you mentioned, the principle was free and fair elections, and the court considered that the lack of proportionality in the British Act of Parliament was against this principle. So in the recent migration clash, do you know what was the principle of the ECHR that the court considered was clashing with the practice of the Home Office?
Yes, so I think that in the context of the Rwanda policy that was tabled by the Home Office, we are perhaps witnessing another problem. It doesn't concern democratic rights, but it concerns Article 3 of the European Convention on Human Rights, which is the right against torture and inhumane and degrading treatment. So this right is incorporated in UK domestic law via the Human Rights Act. And one of the obligations that derive from this right is that you cannot remove an asylum seeker when there is evidence that removing this person to his or her country of origin might lead to risk of that person being persecuted and having his or her right violated. So this is the legal parameter, if you want, of the situation. Now, the problem is that in the Rwanda policy, which is basically based, or at least heavily informed by a memorandum of understanding between the UK government and the government of Rwanda, the problem was a dispute about whether there is enough evidence as to whether someone being removed to Rwanda for the processing of his or her asylum claim, whether there was enough evidence that he or she would have his or her convention rights respected. This is where the tension is, basically. It's whether it's about the implications of sending these individuals, these asylum seekers to Rwanda with respect to their convention rights. Because, and I think that's maybe one important principle that we might want to discuss, the UK government has human rights obligations both within its territorial jurisdiction, but whenever it acts abroad, it still has the same obligations, or at least to a great extent, the same obligations as if it were acting within its own jurisdiction. I
see yeah. Could you refresh my memory, because what you described for Article 3 apply to asylum seekers. Article 3 of the ECHR apply to asylum seeker is basically the Geneva Convention of 1954. So can you, I'm a bit confused here. Did the ECHR in 1950, which is the date, if I remember well, of the convention, already included provisions that would appear in the Geneva Convention of 1954, which I find a bit, at least it's new for me. And if not, could you remind me which jurisdiction is in charge of the enforcement, or at least litigation about the Geneva Convention, if you know that?
Yeah, so I mean, it's very important to distinguish different international treaties here, and to remind ourselves that the European Court of Human Rights is only empowered to interpret the European Convention, and it's the Article 3 of the Convention that it has stake. Now, it's also the case that this particular provision, the right against torture and degrading treatment, is protected via other international treaties to which this or that state may be a party to. And actually, the European Court of Human Rights might very well refer to these other treaties in order to strengthen the existence or the non-existence of this or that obligation. But
so yeah, so the
European Court of Human Rights, yes, interprets the convention rights. Mm-hmm. And Article 3, I would say, is a bedrock provision of that convention.
All right. And I'm just checking if this article mentioned explicitly, because it's quite important, explicitly asylum seekers, or if whether it's, yes, I have it. I have this article now. Article 3, prohibition of torture. No one should be subjected to torture or to inhuman or degrading treatment or punishment. So it's a very broad principle, not limited to asylum seekers. So it might well be also that the court has been interpreting this this article in light of other international treaties that have specified here and there the statuses of various categories. And here, this is the case of asylum seekers. So on the basis of Article 3 of the Convention, the European Court of Human Rights considered that when the British government has been basically deporting people to Rwanda, it had not taken sufficient measures to make sure that Article 3 would be respected for those people, and that they would not be returned to countries in which they have a serious risk of facing torture or degrading treatment. But did the court consider at all, or not, because this is what you seem to imply, that the court did not consider that the simple fact of returning those people, of sending those people to Rwanda, was a form of degrading treatment? So the sending those people to Rwanda is not a form of degrading treatment, but because they may not have a fair asylum procedure, they may be sent again later to other countries where they would have this degrading treatment. Is it the case, or did the court could the court consider that this transfer to Rwanda was in itself some form of degrading treatment? Did I make myself clear? Or?
Yeah. So I think this is where it's very, very important to come back to what exactly the European Court of Human Rights did in this matter. So the intervention, if you wish, of the European Court of Human Rights in this matter is not a judgment. It is what we call an interim measure. So this is a very special procedure that is only used in exceptional circumstances. But it is particularly relevant to asylum removal cases because there's an issue of time. In that particular case, in fact, I think it was a matter of minutes that when the European Court of Human Rights issued this interim measure. But it's the nature of the function of the interim measure is basically just to block a particular process derived from a policy or a piece of legislation from this or that state party to the convention. But it is not a judgment. It is not a judgment because, in fact, and this is another important principle of the ECHR system, these individuals in question, these asylum seekers, have not yet exhausted domestic remedies. That's the legal term. They have not yet exhausted domestic remedies because their case is still pending for what we call judicial review in the UK legal system. Judicial review is an important part of the judicial process in the UK, where a court is going to consider not the substance of a particular policy, but the process by which this or that judgment was issued. And it's very important, therefore, to understand that this is not the end of the story at all. We still need to see the result of that judicial review. And then, in case these applicants, these asylum seekers are unsuccessful, they then could appeal and bring a case to the European Court of Human Rights. And then there will really be a change of system between the UK system and the European human rights system. But so far, it was just, if you want, a surgical measure
Yes.
by the European Court of Human Rights, which is binding. So the UK had to abide, but it is not yet a decision of the court in the sort of conventional sense of the term.
I see. So the ultimate principle that was at stake was this Article 3 principle. But even before that, in this interim measure, I understand there was another principle at stake, which is the giving people the capacity to exhaust legal resources available within the particular legal system in which they are. That is, it seems to me, some kind of principles related to having access to court. Basically, it's what is at stake here. No.
Yes, I think it is that, but it is also more than that, because I think you're suggesting that the exhaustion of domestic remedies is in the interest of the individual. But I would say that it is perhaps even more in the interest of states. So the concept of that is underlying the principle of exhaustion of domestic remedies is the principle of subsidiarity. So it's the idea that state parties to the convention in this case should be given a primary role in giving effect to the convention rights. Therefore, it is empowering domestic authorities and in particular courts. So this is important because it says something about the broader system of the ECHR, which I think is more about domestic authorities than it is about the court, because the convention gives a lot of primacy and discretion over how the convention is implemented domestically. Okay, so of course it is important to individuals as well, because they can have, as you said, access to a court and to the sort of legal and judicial system from, let's say, a local court to an apex court. And so they can try to claim their rights in each and every, before each and every instance. And it's only in the last resort that they can bring their case and lodge an application to the court.
But here in that, I mean, I understand that giving states jurisdictions primacy in handling cases is in the interest of state, that they want to have first and foremost the capacity to handle certain cases, and if only there is a pending case, that case can go to the European Court of Human Rights. But I understand that in the particular case of eviction of migrants to Rwanda, there was some attempt by the Home Office to deprive those people from the capacity to push their case to have their asylum application dealt with in the UK. So it's also here that the Home Office was trying to accelerate the eviction of those people. So in that particular case, the lack of exhaustion of domestic remedies was in the interest of the Home Office and signaled the urgency in which British policymakers were to get rid of those people. And there is also this issue in the EU, that is this notion of hotspots and swift removal of people from the EU. So I understand that here the UK was trying, I mean, the Home Office was trying to get rid of those people quite fast, because they know that the longer those people stay inside the UK, the more difficult it's going to be to eventually get rid of them. But by doing so, they were infringing the access for those people to, I mean, the capacity of those people to exhaust domestic remedies to push their claim, and actually defend these principles that is in the Article 3 of the European Convention on Human Rights, that is not to be sent in situations in which they could face degrading treatment. So all this seems to me very, very interesting and tells volume about the situation in which we are today. So there is still something I am not sure to have understood, but so let's leave aside the issue. Okay, I understand that actually the European Court of Human Rights has not made clear whether it's the problem was beyond the question of the exertion of domestic remedies, was that these people could be sent eventually in locations where they would face degrading treatment, or whether this transfer to Rwanda was in itself a degrading treatment. The court has not clarified this issue, as far as I have understood. So far, it's simply that the respect of Article 3 was not, there was no respect of Article 3 because those people could not exhaust domestic remedies before being sent back to, I mean, being sent to Rwanda. Do I explain things correctly, or did I miss something?
Yeah, I mean, I think that's correct. But if you want, I can try we can try to make a distinction between rights on the one hand and procedure on the other. So the issue with the exhaustion of domestic remedy,
yes,
is a procedural issue that concerns everyone and every potential or actual application before the European Court of Human Rights. But the issue of rights really has to do with the extent to which, again, there is evidence of a risk of Article 3 being compliant with.
I think the point is made, and the point is clear to me, that is there is indeed this increasing tension between the immigration practices of the Home Office, and again, it's not limited to the UK, it happens elsewhere in Europe, but there is a clash between the practices of the Home Office towards immigrants and deeper principle of the post-war.
I would say you're absolutely right in pointing to that tension, but perhaps I would say that this is almost a classical tension between policy on the one hand and rights on the other. So the Home Office policy is justified upon its desirable outcome, which is to, for instance, discourage people from crossing the English Channel. It's also meant to break the criminal networks of smugglers. All of this has to do with the effects, right, of introducing a piece of legislation, of introducing a new policy. But the problem is that rights, and that's a classical, I would say, philosophical tension, rights are supposed precisely to trump utilitarian, what we call utilitarian or consequentialist considerations, right? So I think this is a quite classical conflict. I mean, if we sort of abstract from the particulars of the situation, the Home Office and the kind of concern for the increasing number of asylum seeking applications. If we abstract from the convention context, this is basically a conflict between policy and rights. I guess as a human rights scholar, I think it is important to re-emphasize the notion of rights in this context. So this is precisely where rights matter. It is even when there is, even if the Home Office were able to substantiate the claim that adopting this policy will have an effect that they want, basically to stop or at least to decrease the number of asylum seekers crossing channels and to break these criminal networks. Even if that were true, you can still wonder if it is rights respecting, in fact. And I think the answer is no.
Yeah, but I fully agree with you that it is a classical tension. But on the other hand, I think it's not without reason that we have this tension in that particular case. And actually, this tension is on the one hand classical, on the other hand, it's vital, because the executive branch is always ready to bypass rights. That this is the basis of tyranny. That is, tyranny is the lack of arbitrary decisions. That is, the ultimate willingness of power is to be unbound. And so the executive branch will always try to achieve what it wants to achieve without regard for previous commitments. So there is this tension. It's a classical tension, but it's actually extremely a serious tension as well. That is, in this tension, there is the question of law and order to some extent, and control, I mean, checks and balances over the authority of the executive branch. So what I am interested in is that this tension here emerges in relation to the immigration policy.
Mm-hmm.
And it emerges in relation to immigration policy, and at the end of the day, also, what matters in this tension here between rights and policy, I mean, the underlying problem is a very important principle also, which has to do with the dignity of the human person. We are not talking about a clash between rights and policy for a trivial matter. Here, we are talking about a very deep principle, which is, as you say, people should not be submitted to degrading treatment. So we are talking...
Absolutely.
And I just finished this point. I mean, we are talking about fundamental principles, and we are observing a tension that, albeit classical, is fundamental to avoid tyranny and to avoid abuses of power, the respect of rights by policies.
Yeah, I mean, I could not agree more. I would just add to that the Human Rights Act, if we take the specific case of the UK, was precisely introduced to prevent this kind of abuse. So to give you another example, which will be quite legalistic, but I think it does emphasize this aspect. Under the Human Rights Act, a government minister in charge of presenting and introducing a piece of legislation before the UK Parliament has, as a matter of procedural obligations, he or she must explain how the piece will be compliant with the European Convention on Human Rights. Just to give you an example of the upstream role of the ECHR in the Human Rights Act. So it's not just via the judicial process and potentially the role of the European Court of Human Rights reviewing a case, which, as we saw, takes place downstream. And it can take a lot of time for a particular application to reach the European Court of Human Rights. It's also that the convention matters in the sort of ordinary, the sort of almost the routine lawmaking process in the UK. And I think you're absolutely right that the function of the convention in that particular context is to prevent abuse at different stages of the political process.
Yes, so I think that can conclude the first part of our discussion. That is, what was at stake in the intervention of the European Court of Human Rights in relation to this transfer of migrants to Rwanda. What were the principles defended and the procedures, forms of procedures defended? And so it opens, I think, a second dimension in the discussion, which is what is ECHR about? And here we can go back, as he suggested earlier, to the context when this convention was negotiated. I did not study those archives. If I remember well, these are documents that may be related to the archives of the Council of Europe. And even though the court is not part of the Council of Europe, it's a separate entity. But so I have my own idea about that. But before giving it, I would like to ask you what you think, what the context, why setting this text, and you say the British government itself was a major proponent of this text, the European Convention on Human Rights. What was, according to you, the reason why lawmakers signed this treaty?
Yeah, so this is, I think, a big question that I think has actually attracted a number of scholars across disciplines. So there are different arguments, but I think they do overlap to some extent, at least, in the idea that the European Convention on Human Rights was basically an instrument to lock in democratic credentials after the Second World War. So I think this was
after the Second World War, or after Nazi totalitarianism?
Well, I think that it has definitely resonated with the horrors of Nazi Germany, but I think it had even from the start a broader objective of preventing the return of any kind of totalitarian forms of government. Now, I think it's very important to look at the work of historians, of legal historians, to really understand the nuances of why states drafted this convention, because I think that if you look at the context, the sort of broader European context at the time, and you take the examples of the UK and France, we're still talking about two powerful European states with still some colonial possessions. And it's very interesting to see that both the UK and France, although they were among, again, the promoters of the convention, they ultimately signed the convention pretty late. So the convention itself dates back to 1949, 1950. But the UK, for instance, I think waited until the 70s, if I remember correctly, to sign the document. And historians point to the risk that signing and sort of potentially giving effect to the convention in domestic law would have drastic implications on how they were ruling their colonial possessions. So again, although there was an inspiration and there was a narrative behind the creation of that convention, if you look at how states really related to that convention, you see a different array of interests and motives. And you can say the same, for instance, about a more recent development in the relationship between the European Convention and the fall of communism, for instance. So the convention has been also very important to consolidate the Western Bloc and to give these all these former communist states some foundations, if you wish, of liberal democracy. So I don't want to say too much about the historical dimension, because I think this is the work of legal historians. I just want to give you an overview of how complex and interesting it is to sort of draw the different narratives in that relationship between the founding states, and then also how the convention evolved and sort of played different roles in different historical contexts. But if I could say just one more thing about the founding moment, I think that the most interesting aspect is basically how these governments and basically how these diplomats discussed and ultimately included a certain number of rights in the convention. And if you look at the convention, some rights that you might take to be quite intuitively connected to human rights were not included. Or they were included in further protocols to the convention later on. And all of this is very important, right? Because it sort of shapes the identity, if you wish, of that particular convention. So, for instance, there's a very, I think, I've been working in particular on the right to free and fair elections. And this is exactly an example of a right that was added via a protocol to the convention list. And you can wonder why, right? Because it seems to me that this is a right that is part and parcel of the democratic process. So looking at history, I think, is a very interesting way to problematize what this convention is about.
Yeah, I think what you say also probably echoes my own view on this issue, which is that this convention occurred in a context that was still very much affected by the horrors of the Second World War and Nazi totalitarianism in particular. This is also the time, it's just before actually, so we cannot say that it was a factor, but it's around that time that Hannah Arendt is writing her book, The Origins of Totalitarianism. It was published in 1951, so we cannot say it has influenced the drafting of the convention, but actually both may be related to the same spirit after the end of the Second World War. And also you mentioned the question of communist countries as well, and how the convention served to consolidate the Western group of states against the Soviet Union and satellites. So what I think is at stake in the convention is this idea that if state power becomes total and disrespects certain principles, then this domestic situation can spill over in the international system. Hence, the importance of having this convention, that it's big, that will bind every state. And those states that were, to some extent, the winners of the war and those who were trying to prevent a repeat of Nazi totalitarianism were ready to sign, but also among the most reluctant to sign. Because what they wanted first and foremost was to bind others But actually, they could do it only by having a multilateral agreement in which they would have to be bound. And therefore, it's decided that yes, you have totalitarian practices developed in one country, especially if it's an important one. This spills over into the international system. And here there are two cases: Nazi totalitarianism and Soviet totalitarianism. So what is interesting here in the intervention of the court that we are discussing about human rights is this idea of not inflicting degrading treatment to people. And this echoes also the theory of totalitarianism that Arendt was developing at the same time, and which it seems to me is the best theory so far of totalitarianism. And in the theory, the ultimate stage of totalitarianism are related to the destruction of the person. And she identifies 3 steps in the destruction of the human person. That is, first, there is a destruction of the legal person, then the destruction of the moral person, and last, the destruction of the person as having distinct characteristics. That is, people differ from each other, and they are unique to some extent. So the first part is the destruction of the legal person, which is you deprive people of rights on a massive scale. Then you destroy the moral person, that is, you deny the possibility for human beings to become, to serve as example in their communities or for the future, to develop moral characteristics that will identify a person as an example. And last, the destruction of the person as having distinctive traits from the other was happening, according to Arendt, only in camps, in which you have only a mass of people who no longer have distinct characteristics. So what is interesting in this theory is that this Article 3 was meant to uphold the first of these 3 moments, that is the destruction of the legal person. Again, I am not saying that the convention was predicated upon the theory by Hannah Arendt, but I think that the theory is the best we have to understand the origins of totalitarianism and how totalitarianism emerges. So, yes.
I mean, there's a lot in what you just said that I think we could zoom in. So if I may just add a couple of, I mean, maybe one thing to each of the things that you've said to reinforce some of the points that you made. First, with respect to, just to finish on the sort of founding or the sort of early phases of the convention system, I think it is just worth recalling that initially there was no permanent court of human rights, permanent European Court of Human Rights. Initially, there was a commission that was in charge of filtering. It was a filtering mechanism for claims of rights violations, violations of the convention. So in fact, initially, I don't think, according to my reconstruction of historical work on this particular time, there was no necessary assumption that this system would become what it has now become, which is this very well-respected permanent court with compulsory jurisdiction. So you have to do the history of that institution to understand the different functions that it was supposed to serve. So initially, a historian of the European Convention, Ed Bates, called the system an alarm bell system. So the idea was just to flag when there was a potential risk of the return of totalitarianism, whether it was irrespective of its particular nature. So at that time, I think in the first decades of the court being in existence, in fact, it was the Commission that it was the most active, and we are not yet in presence of this almost quasi-constitutional court of Europe that we have now. So that's the first thing. The second thing is that just a small rectification. What I said was that on the one hand, the convention was an instrument used to consolidate the Western Bloc against the communist bloc initially, right? But then, with the fall of communism, it was also an instrument to strengthen and to secure liberal democratic credentials for these states. So there are different periods, and I think the relationship between the convention and these this part of Europe is absolutely fascinating. And then finally, with respect to Hannah Arendt, so I think you are absolutely right that Article 3, I think, highlights a number of foundational issues and questions with respect to, on the one hand, the concept of human rights, and with respect to the concept of totalitarianism on the other hand. So you said a little bit about totalitarianism. I can say a little bit about the concept of human rights that Arendt had in mind, which, and I think she coined the phrase, the right to have rights. And that is basically a definition of rights as enabling and protecting membership in the political community. And today in the literature, you have theorists of human rights who do understand the concept of human rights along these lines that were initially developed by Hannah Arendt. And now you can wonder, or you can, let's say, better understand why the issue of migration is so salient and so divisive and so loaded. I think it is because it is mobilizing these foundational issues of membership in the political community and who can be part of the political community. So you're absolutely right that I think Arendt could be an interesting interpretive paradigm here. I haven't really come up with elaborate thoughts on that, but I think it is difficult to disentangle the issue of migration on the one hand and the issue of political membership on the other.
Yeah, I think this leads us to a third part of the discussion. That is, first, we are trying to understand what was at stake in the clash between the Home Office and the court in the recent events. The second part of the discussion was to understand what was the origins of those principles at stake in these recent clashes. How did they fit in a particular historical context? What was the rationale? And now in the third part, as we have identified the principles at stake and the origins and the historical dimension, is to say what all this tells us about what is really going on now, what is at the deep political level. And you say that the fact that the British government clashed with the court about migration may have to do with issues of membership. I may have, I think, a slightly different interpretation. I think that there are two factors that are at stake in this. From this point of view, that is, on the one hand, the logic of migration policies is increasingly at odds with a basic respect of the human person, and therefore basic respect, I mean, of principle aimed at preventing totalitarianism. And on the other hand, it's that the immigration policy, I mean, here we talk about restrictive immigration policies, have become a fundamental aspect of state policies. And therefore, we have such a major clash. So, as you say, there are other factors in the fall of the Johnson government. I am not simply saying that the Johnson fell because of the decision of the court. Of course, there is a variety of other reasons, but I would still push the claim that this affair has been of major political importance and has contributed to destabilizing this government in a critical moment. So this government had been increasingly built around the idea of restricting immigration. To some extent, Brexit was also about restricting immigration. The Home Office had become obsessed with irregular crossings in the Channel. It was becoming more and more this government would owe its capacity to stay in power to its capacity to restrict migration effectively. And this agenda is increasingly at odds with the basic respect of the human person. So those two forces, I think, are at the origin of the clash. And I will say things a little bit bluntly, which is that I think that immigration restrictions have become an exercise of absolute state power. That is, state power getting absolute in the sense that getting unbound. Absolute origin etymologically means being unbound. And is typically this kind of policies that could spill over into the international system. I think there is a potential, and this is what we can discuss, there is a potential, I mean, a totalitarian potential in the continuation of restrictions to immigration, and at the same time, states in Europe increasingly build themselves around this question of restrictions to immigration. So a dynamic in which a vicious circle of increasing restrictions, and it becomes the basic raison d'être almost of the state to restrict immigration, a process which itself leads to a totalitarian pathway. I mean, it's, of course, it's an aspect of a totalitarian pathway. I would not say it's all the totalitarian pathway. It would be absurd, but it's an aspect of it. That is, it's part of a negation of the dignity of the human person. You cannot have an agenda of restricting immigration and at the same time having the dignity of the human person as your primary concern. This is not possible. And both objectives come to clash. And this objective, immigration restrictions, leads to attacks against the dignity of the human person. So what are your thoughts on those two aspects? That is, first, is the restriction to immigration, you think, deeply at odds with the principles that have founded the post-war international order, as they are found in the European Convention on Human Rights? And secondly, do you think that immigration restrictions have taken such an importance in a variety of debates and policies in Europe that they nearly become the raison d'être of states.
Yeah, so I mean, this is all very, very interesting, and I mean, I agree with some of the premises and some of the conclusions, but I would probably add one component to this analysis and to this sort of sequence, which is populism. So I think that the reason why there is such an emphasis on immigration, or at least one reason for why there is such an emphasis in immigration these days, is that it helps capitalize on one of the populist principles, which is that there is a real, authentic people. So that's one, I think that's one element that is distinctively populist. And the reason why it is connected to immigration is that, in fact, it is, according to the populist ideology, it is up to the people, and only to the people, to these imagined, idealized people, to decide. So I think that only then you can explain why some
just a parenthesis here, very short parenthesis. Do you think that these people is simply a projection of the state? Because these people is actually a number of individuals that happen to be under the jurisdiction of the state. So it's a projection of the state. It's authentic people that you describe, of which immigrants are not part. They are a projection of the state. They are a shadow of the state.
Yeah, absolutely. But I would be slightly reluctant to talk about state, because I think what we have is just governments, and government in the UK, you have, let's say, points of reference, such as, you know, the manifesto of the Conservative Party, for instance. And I think to talk about the state in the abstract sense, I think it is, the risk is that you're going to obscure the role that government plays in basically in surfing on the populist wave. So I think they are very, very well aware of what they're doing, which is to stimulate the populist resentment by emphasizing again and again the issue of immigration. By the way, if I wanted to be as charitable as I could be with the UK government, I would say that they are not necessarily restricting immigration. They want to get back control of the immigration. Now, this is important because it suggests that this is going to re-empower the people again. Okay, so I fully agree with you that this is a complete projection, that it is a completely simplistic and idealized account of who the people are and what their interests are. And by the way, I would also agree with your diagnosis that there is a totalitarian, or at least an authoritarian potential. But this authoritarian potential has been very well identified by scholars of populism. So once you get rid of basically most instances of deliberation, of mediation, of strong separation of powers, if you get rid of all of that and you place all your faith in an acclaimed leader, because populism, to a large extent, needs a strong leader, a leader that can almost incarnate the people, that can at least very strongly resonate with them, then you basically run the risk of this or that leader abusing power, abusing the power that you conferred to him or to her. So that's where I think the authoritarian and maybe totalitarian potential lies. It is that populism is basically empowering particular individuals at the top of governmental action. And it is very, very tempting for a strong leader, a government leader, to abuse power when all these counterpowers have been eroded. So that, I think, says something about your point about the significance of the immigration topic to the almost to the meaning of the state and how people identify to what they identify the state. I would just be careful about the state. I think we have governments and we have manifestos and we have policies and we have laws, and all of that is a political process conducted by particular people, and I think we should really pay attention to that. There's a lot of research on the concept and the broader meaning of populism. I think that's very important at the level of foundational research, but we should also take a look at what populists do when they are in power, and specific policies and pieces of legislation that I think are doing the work, almost, as you said, I mean, almost in the shadow of the political process.
Yeah, again, what you say about populism echoes some of the elements of the theory of totalitarianism of Hannah Arendt, but the ultimate stage was destruction of the human person. But there were two previous stages. The first stage was the elimination of any alternative source of power, which is despotism. And the second stage was what she called the movement. And we discussed this issue in the previous episode of this channel in the case of France. That is how our elections, more specifically, are taken over by movements which are dominated by one leader. You have those of movements are fluctuating. They don't have internal structures of checks and balances and controls and selections. They have one leader and everything gravitates around that leader. And the movements, the emergence of movements, is for Arendt absolutely crucial to reach the ultimate stages of totalitarianism. So what you refer to with populism is echoes also this model. But
so one thing that I think I would add with respect to what you said about the clash between this new meaning of the state and the dignity of the individual. This is where I'm going to be slightly careful in using the term dignity, because I think there are several reasons. There are philosophical reasons that I think we should consider when we give meaning and substance to the notion of human dignity. So this is a heavily debated topic. But I think there's also a legal reason, which is that with respect to the European Convention specifically, and it's an interesting fact about the Convention, is that it doesn't refer to dignity, unlike, of course, the Universal Declaration. And I think that there's a reason for that. The reason is that, in fact, this convention is as much about respect for individuals, and then, of course, you can bring dignity if you want, provided that you have a strong definition of dignity. But also it is basically about a process, which is democracy. So you have a lot of references to distinctively political values and democratic values in the convention and in the preamble to the convention. This is not to say that dignity has no role to play either at the sort of normative level of when we want to prescribe a particular meaning to human rights into the convention, but also actually dignity has appeared in cases before the European Court of Human Rights. But it is very interesting to notice how. So it is not necessarily via judges and the court relying on dignity, but it is because applicants, individuals, have referred to dignity as part of their case. So this is just one nuance. I think we are very quick in talking about dignity when it comes to understanding the broader function of human rights. And I think that's very important. But I think that there are some nuances to bring into the concept of the convention that are quite interesting. That's just a really important nuance to me.
Yeah, so this overall discussion is about whether in the recent events between the Home Office and the European Court of Human Rights, there is not something bigger. A little bit when you observe a clash between two groups of soldiers, and you are wondering if this clash simply between those two groups of soldiers, or those two groups of soldiers aren't they part of two much bigger armies that are here clashing. And so what would be bigger here than the simple affair of the eviction of migrants to Rwanda is that unchecked state power leads to leads both to dramatic actions against immigrants and to infringement of public liberties, and you refer to human dignity as a broad term, which have a totalitarian potential. That is, at the end of the day, what we observe is that our state power is unchecked. And our state power is unchecked leads that state into harsher and harsher measures against immigrants. And at the same time, it leads also the state to on a totalitarian pathway. And what maybe, I mean, we are a bit nice here with the European Court of Human Rights, but it's my view is that it's a little bit like a machine, this court. That is, as you say, I like this idea of the alarm bell. That is, it's a machine that reacts to a situation. It's a bit like a thermometer that would tell you oh, the temperature is rising. Generally, lawyers love to consider that courts have a lot of agency in politics. Personally, I am not that convinced, and I would rather see yes, the court as a form of thermometer, and facing a bigger army, which is the army of increasing state power, concentration of state power, unchecked state power, and leading to harsher and harsher policies against immigrants and a totalitarian pathway for everyone. Because the European Convention on Human Rights is not about immigrants primarily. I don't know how many times the word migrants come in the convention, but probably very few times. It's a much broader text meant basically to enforce certain principles in domestic politics and prevent a totalitarian path from developing in domestic politics and spilling over into the international system. So I think what this story tells us is that immigration is itself a signal. I mean, immigration policies are a signal of how the state gets unbound. My own analysis, my own view on this is that with more limited state power, at some point, immigration restrictions would stop because it's a little bit like the First World War. That is, you had this war lasting for nearly 5 years because the states were extremely powerful domestically. Had the state been like the monarchs even of the 18th century, the war would not have lasted that long. Many people would have refused to get killed massively during the First World War. Likewise, if the power of the state was less important, there would not be the potential for such a high degree of immigration restrictions. So I think that what we are observing behind all that is our state power is increasing, and immigration, because you say that what they want is to get back control, but I would tell them a very easy way to get back control, being less restrictive. If they were less restrictive and they were simply identifying migrants and recognizing their employment or conditions in the country, I'm sure there would be no problem. It's because they want to restrict that it's so hard to get control. The smugglers exist because the legal travel routes are blocked. So yes, I think there is something bigger, which, as you say, can be also part of populism, which then takes a broader dimension, not limited to immigration. But I think yes, that's what at stake.
I think I agree with you, but I think I would I would add one dimension to the story here, which is that if we want to try to see this issue in a broader fashion and to identify the sort of more perhaps stronger and underlying forces that it points to, I think we haven't really talked about the thing that is supposed to adduce limits to state power, and therefore to this trend that you have identified, which is the increasing state power. It is the Constitution, and it is the type and kind of constitutionalism that we, conventionally define and distinguish between a state like the UK and a state, say, like Germany. Because the difference is basically that in the UK, you still have a strong form of what we call political constitutionalism. Now, I want to say, or maybe that's still a hypothesis, that the type of constitutionalism that you have can operate as an enabler of populism. Because again, if you don't have a strong constitution,
yes,
written constitution with a clear and sort of entrenched separation of powers, yes, with individual rights, then you basically create an ecosystem in which populism might just thrive. So of course, people are going to think that I'm just a basic defender of legal constitutionalism, which is the kind of model that we have in continental Europe. But I don't think that you need to be a legal constitutionalist to make this point. I think what is at stake here is just this assumption that there is very deep in the political constitutionalism model, whereby the assumption is that it's Parliament that is the best guardian of our rights. This is the assumption of political constitutionalism. So it should not be up to the judicial organs to protect those rights. It is not therefore desirable to have an entrenched and enforceable list of rights. It is best that Parliament. But what happens if Parliament starts disrespecting fundamental values of constitutionalism. So it is an assumption that Parliament will do this job best. But what happens if the Parliament is basically becoming an instrument of the government that is basically just conforming to what the government wants? This is basically the principle of the separation of powers being dissolved in front of our eyes. And I think it is interesting to run this analysis of which kind of constitutionalism is enabling or preventing this kind of populist threat, and therefore the sort of authoritarian or totalitarian potential. And I just want to raise that question, because I think if there is some underlying condition that can do some explanatory work, it is the kind of constitutionalism that we have. And it is not a surprise that populists, when they reach office, they start changing the constitution, right? Because they want to aggrandize their executive prerogatives. So constitutionalism, I think, is an important concept. I think that was my point.
Yes, absolutely. That is, if you are faced with, I mean, the ultimate, I mean, the legal barrier against totalitarianism is the constitution with its checks and balances. But you can have a formal constitution and at the same time run the risk of totalitarianism when the checks and balances within the constitution do not survive the pressures, the political pressure. But simply to maybe to conclude this discussion about the what was going on in the clash between the British government and ECHR, is I think we agree to say that there is an increasing involvement of the state. The state is increasingly at odds with certain principles to enact its increasingly harsh immigration policy. That we agree on that, and but what you said, and I find it very interesting, that this increasingly harsh restriction policies at a very deep level is related to the definition of the people by the state. So I have my own view on why do we move towards increasingly restrictive migration policies. I think there is some kind of path dependency in this evolution, with one restrictive measure triggering a variety, leading immigrants to trigger other problems that lead to even more restrictive measures. There is this issue, but at the deepest level, there is a question of who the people is. And what ignites this path dependency is a definition of the people that is quite restrictive and predicated upon the interest, the survival of the state. That is, it's a group of often native, but at least long settled inhabitants of the country, and this group of people is the state plays on that group at the expense of the mobile, that is playing upon the immobile at the expense of the mobile. And the state increasingly owes its influence and its power to its capacity to be acclaimed by the immobile. I mean, immobile in a relative sense. So at the deepest level, and this is something already also related to who has the right to vote, for instance, migrants or only the natives. At the deepest level, what we are observing is that the state is getting consolidated, is getting concentrated, is getting unchecked, based on a definition of the people, which maximizes some form of defensive territorial interests
Yes, I think that's right. I think it is an important aspect of the analysis. I would just maybe add two things. One is that if you listen to what Boris Johnson has been saying all along, even in recent weeks, is that the mission of the UK government was to deliver on the priorities of the British people. And I think this kind of discourse basically is sort of, it starts and it ends there, because there's never ever even an attempt to define these people in the first place. So that's one thing that I think there might be some limit to how much political leaders can say about that. But the question of the people in political philosophy is a very important and I think contentious one. It takes us into questions of, for instance, who is affected by the actions of the state. To what extent someone who is even remotely located, but somehow is affected by the state, can that person be considered part of the people? So the demos, the question of the boundaries of the people, as it is called in political philosophy, I think it is a very, very interesting and difficult one. And you can see why the political class is almost playing with that, right? So yes, I think that's right. I think that there is this underlying question, which again, I think from my perspective, it makes the convention even more relevant, because the very concept of human rights suggests that you have and can exercise these rights outside of any form of political membership, right? It is these rights that we have just in virtue of being human. So there is, I think, a more fundamental clash here conceptually between human rights on the one hand and the people, the state, the political community on the other, and how we're going to articulate this relationship, I think, is key conceptually speaking.
Yeah, I like your last expression, the people of the state, because in contrast to the people of human rights, which are humans, and the people of the state actually are a projection of the state, and behind this debate about immigration is the question of how the state defines the people and how it does it to defend some territorial interest, which leads to a sequence of increasing restrictions to immigration, and also to rising state power and a risk of totalitarianism as well. So yes, I think that to end up here, I think my view on these things is that the European Court of Human Rights still plays a very important role in trying to keep states in check. It's a form of vertical checks and balances, and this there is a clear clash here between, on the one hand, the immigration restriction, the immigration policies, and this principle upheld by the court. So thank you very much, Alain, for your time and for sharing your views on this crucial aspect of the current political system of the UK, but not only. Many other European countries are actually in the same situation. All right, okay, thank you. Let's stop it here.
Thank you for your invitation. I really enjoyed it.
Okay, thank you.